Good morning. I'm glad to have the opportunity to give my presentation for you. I hope you are well after the break, and I promise that it won't be long. The topic of my presentation is the status of an office of an international organization from the perspective of the internal law of the host country, and the inspiration was the process of ratification of some agreement between Poland and one of UN institution which is established now in Warsaw. First of all, I would like to introduce my topic, presenting some introduction to the problem of the status of international organizations in general. So international organizations are, of course, the subjects of international law, but these are subjects without territory. That's why they have to operate on the territories of sovereign states. And every international organization has, of course, its headquarters, which is located in a particular host state. The biggest organization, like, for example, UN, have also the other offices in many states. To perform their functions, they should have, first of all, the legal personality under not only international law, but also under domestic law of states. And in order to perform their functions independently, they also should be granted appropriate level of privileges and immunities by states. As we are talking about the legal capacity under domestic law, we are talking about some prerequisite for international organizations to effectively manage numerous practical needs, such as, firstly, the procurement contracts, acquisition of property, and capacity to pursue its private law rights before national courts. So this is the basis three competences according to domestic law. Why the legal personality and the capacity is necessary? I hope it is not needed to present because it's obvious. So what are the reasons to grant the privileges and immunities? So the first reason is simply to protect the independence of the organization, because without privileges and immunities, international organizations themselves and their officials on the territory of a particular state would have simply the same status as any other foreign institutions and just common foreigners. So privileges and immunities are for ensuring that national authorities may not unilaterally interfere in the operation of the organization, either through direct action against the organization or against its officials. So we have the first reason, it is independence, and the main role plays, to gain the independence, plays firstly the jurisdictional immunity of the organization itself and of persons who perform functions and are connected with the organization. And the second privilege, which is very important, is inviolability of the premises of the organization and of its high officials. The main immunity, jurisdictional immunity of different has different justification compared to states' immunity. Why? Because jurisdictional immunity of states is based on the principle of the sovereignty of states, sovereign equality of states, and it's reflected in the notion parim parem non habet imperium. So the impossibility of judge the equal sovereign state. And jurisdictional immunity is based on completely other reasons, because it is only a functional necessity. And according to Rosalind Higgins, She said that it proceeds from the desire that an organization established by a group of states to carry out common functions should not be subject to unilateral interference by one of these states outside the mechanism of participation provided for in the structure of the organization. So this is the justification for jurisdictional immunity. It is only the functional necessity, not the equal position between the subjects, like by the jurisdictional immunity of states. And the other reasons for giving the immunity and privileges for the organization is simply facilitating the work of the organization, because the organization are connected with a need to transfer funds, move goods, and communicate with its staff, so it will be easier to have some privileges and immunities to simply do the business more effectively and as smoothly as possible. And the third reason to give the privileges and immunities is to ensuring the equality of member states and preventing the gaining of an undue financial advantage. It is connected with some possibility to have some extra money from the taxes, which will be paid from the common assets and funds from the organization. And now I would like to present the legal basis for giving privileges and immunities of the organizations. And the first and the main sentence is that there is no universal convention. So we do not have any codified rules concerning international organization, legal personality, privileges and immunities. The issue has not been codified, and I will present you the reason. So what do we have? We have treaties concerning privileges and immunities, and there are two kinds of those treaties. So there are general multilateral conventions and bilateral agreements. We have also customary law, but to some extent, because we have, as always, by customary law, we have some constraints in the doctrine, some different views about about the problem. So some jurisprudence is also not uniform, but we have the very different views on the customary law concerning the privileges and immunities of international organizations. And we have also, of course, national law. Why do we don't have the universal convention concerning that problem of legal personality and privileges and immunities of organizations? It was almost done because International Law Commission decided to place in its agenda the topic relations between states and international organizations. But the topic was divided into two parts. The first one, the part about the diplomatic law of international organizations, so the status, privileges and immunities, but not of organizations, but of representatives of states to international organizations. And the second part was about our topic, so about the status, privileges and immunities of international organizations and their personnel. And the Commission concentrated its work on the first part of this topic, and this resulted in preparing the draft of the Vienna Convention on the Representation of States in their relations with international organizations of a universal character, which was adopted in 1975. As you know, this convention is 50 years old and still not yet in force. And the Commission began its work on the second part of the topic in 1976. But because of the lack of support for the first convention, they decided in 1992 not to pursue the topic further. So they simply decided that the states are not interested in codifying the issues of legal personality and privileges and immunities of international organizations. So we do not have any universal convention on that topic. So instead of universal convention, which could be applied to all organizations, we have many other treaties. In particular, we have constituent instruments of international organizations, and the constituent instruments of any particular organization usually contain at least a general provision saying that legal personality and immunities and privileges are granted to the organization, its personnel, representatives of member states. Since the general provisions need to be specified because there are only general provisions, the details of those privileges and immunities are to be found in other agreements concluded. So we have the convention, which are concluded between all member states for the benefit of the organization, and we have the bilateral agreements between a particular organization and particular host state. The multilateral convention are particularly important in the context of the Convention on the Privileges and Immunities of the United Nations. So this is the main convention concerning that problem, and on the basis on that convention, we have the states built another conventions concerning another organization. So this was the model convention concerning the problem of legal personality and privileges and immunities of international organizations. So that is the general convention. I will use that let's say notion for the next slides. We have, of course, many bilateral agreements. First of all, there are headquarters agreements, and there are many such headquarters agreements. For example, between United States and the UN, and also the agreement with Switzerland, between UN and Switzerland concerning the headquarters of WTO also. What about domestic law? So, of course, privileges and immunities of international organizations are intended to be enjoyed within the national legal order, since they provide either for exemption for certain substantive rules of national law or for exemption from the jurisdictional reach of domestic authorities. So this means that for such privileges and immunities to be effective, they must be reflected in or at least respected by domestic law. And for this reason, some states have enacted domestic legislation governing the privileges and immunities of the international organization. These laws are usually enacted in order to give effect to the international obligations. So the international obligations are first, and then we have domestic law of the state concerned. But in some cases, they may provide privileges and immunities that go beyond what international law requires. So the domestic law may be even better for the organization than international regulations. I would like to shorten. As I said, the inspiration for my presentation was the case of Poland and the ratification of some agreement between Poland and UN concerning the Office for Project Services, the last one. But of course, Poland is not a host state for a headquarters of any international organization. It is, however, the host state for some offices of international organization. For example, Frontex, so the European Border and Coast Guard Agency, the Office for Democratic Institutions and Human Rights, Council of Europe Office, UN High Commissioner for Refugees Office, UN Information Center, and the last one which I mentioned previously. So we do not have any headquarters, but we have many offices of international organizations. So the problem is, do we have any law which should be applied to that offices? Poland does not have its own domestic legislation concerning the legal status of international organizations. So we do not have any such domestic law. So what are the legal basis for functioning of these offices? The status of each particular office of the organization in Poland is based on the agreement between Poland and the host state as a host state of this particular organization. As a result, the scope of privileges and immunities granted to particular offices of international organization slightly varies. So we do not have the same rules for for every organization. We have different rules for the organization. However, the basic privileges and immunities are granted. So jurisdictional immunity, inviolability of international organization premises, archives and documents, currency and fiscal privileges and immunities with regard to communication facilities, for example, they are guaranteed. What about this office, the UN Office for the Project Services? So the agreement between Poland, the government of Poland, and the UN was signed in New York 2023, and it is ratified, it is in force. The UN Office for Project Services is known because it is a UN subsidiary organs responsible for infrastructure project implementation, procurement and project management, human resources, finances, and this UNOPS purchases goods and services from suppliers around the world, worth approximately $1 billion annually. So there is also some interest to have an office of such an institution on the territory of the state. Of course, UNOPS headquarters is located not in Poland, it is in Copenhagen, but it has offices in many countries, in several countries, which facilitates the implementation of projects in a given region and the involvement of local companies in providing their services under public procurement contracts conducted by this institution. Poland was very interested to have it on its territory. This is the statement of Minister of Foreign Affairs of the Republic of Poland. He is interested because it was also some needs that and some faith that we will take part in Ukraine reconstruction, let's say, and to make the path to these contracts easier for Polish businessmen. They are that office in Warsaw will be some good solution. And what is the position of this office in Warsaw? Just to show how it looks like on the basis on this agreement. So jurisdictional personality is granted, the capacity to contract, to acquire and dispose immovable and movable property, to institute legal proceedings, and the office should be represented by the head of the office. The general rule concerning the office is that the office, its property, funds and assets, and its officials, experts on mission and person performing services, the provisions of the UN Convention shall be applicable mutatis mutandis. So in the first line, we should have to apply the UN General Convention concerning privileges and immunities. And the main, I think I would like to maybe shorten the presentation. So the main privilege is the inviolability of the premises of the of this office. But the inviolability is not absolute. So we have the exception. So the Poland's authorities shall not enter the premises to perform any duties, except with the consent of and under the conditions approved by the head of the office. In case of a fire or other emergency requiring prompt protection action, the consent of the head of the office to any necessary entry into the premises of the office shall be presumed, if he or she cannot be reached in time. So this is very reasonable exemption compared to diplomatic law, for example, when the diplomatic premises are simply inviolable without any exemptions. Of course, we have also other privileges and immunities. Maybe I would like to show you the privileges and immunities concerning the officials. So they are granted immunity from legal process in respect of words spoken or written and all acts performed by them in their official capacity. We have also exemption from taxation. Okay, I will short it. Maybe I would like to focus on some details. For example, we have the definition of dependent members of their families, because it is not often in the agreements that we have the definition of what are members of the families, and this is very important because some privileges are not only for the officials but also to the members of the families. And this is the definition of the member of the family, very traditional one, because we have only spouse, child under 21 years old, not 18 but even 21, child under 25 years of age who is in full-time attendance in a post-educational institution, disabled child, and also some persons which are secondary dependent according to the rules adopted in the United Nations staff regulations. Okay, we have also the mechanism to protect against abuse of privileges, because we have the possibility to waive the immunity. The UN Secretary General have not only the right but also the duty to waive immunity in any case where, in his opinion, the immunity would impede the course of justice. Unfortunately, neither UN General Convention nor the agreement does not provide for such a mechanism, which is known in diplomatic law, so we do not have any institution of persona non grata, for example. And it could be a problem if the state will want to simply say that somebody is not willing on the territory. What are the problems to conclude? So, of course, officials possess immunity from legal process in respect of words spoken or written and all acts performed by them in their official capacity, but the term legal process is very broad. So the problem is who is entitled to decide whether a particular act or conduct is official or non-official. So here we have some problem. Who is to decide? According to the doctrine, it is only for the UN to decide, but the national courts are of other thinking. I will maybe present the last slide. On the one hand, the doctrine on functional necessity provides a reasonable criterion to determine whether and to what extent immunity or privileges are granted to an international organization or institution. Nevertheless, uncertainties remain regardless its exact interpretation. So we have the criterion, but the interpretation might vary from court to court. So the other problem is the need for an effective dispute settlement mechanism that international organizations have to provide for as a corollary of their immunity. So they have to get some other system to get the forum of resolve some disputes. For example, some dispute concerning its officials. That is only some shape of this problem. Thank you for your attention. And if you have any question, I will answer it after the presentation of my colleagues. Thank you very much.